Hello, everybody, and welcome to today's webinar hosted by the American Association of Clinical Endocrinologists. This webinar is titled Negotiating Contracts with Employers, Issues to Consider by Both New and Veteran Endocrinologists. Today, Jennifer Papapaniotto and Robert Lyles, both partners here at Lyles Parker, will be discussing the ins and outs of employment contracts. Here at Lyles Parker, they focus their practices on healthcare, regulatory, and compliance issues. Without further ado, I'd like to hand it off to them and start today's webinar.
Thank you very much, Andrew. Hello, Jennifer.
Hello, Robert. How you doing this morning? Or I guess this afternoon now.
Doing fine, doing fine. Today, Jennifer and folks on the line, we're going to be talking about contracts. And there are really kind of two aspects we're going to be looking at, two broad aspects. First, we're going to talk about if you're a recent grad, or maybe you're just finishing your fellowship, like a lot of our endocrinologist friends, members of ACE, are currently in the process of finishing their fellowship. There's a number of questions that you want to ask if it's going to be a new contract. And these are some of the things we're going to go through. You know, what are some of the due diligence issues? You know, how should your salary be set up? What about recruitment considerations, non-competes, non-solicitation? You know, if there's a problem, you got to think ahead. Everything is great when you're first getting into these jobs, but what if it doesn't work out? What's going to happen if there's a conflict? Are you required to go to mediation? What's the choice of law? Where's the venue going to be held? You know, what exactly are these factors that you have to think about on the front end? And then, what if you're leaving a job? Okay. What kind of notice do you have to give? What are the bonus concerns that you need to keep in mind? What does it mean to be in a contract that allows you for the contract to be terminated for cause versus without cause? What are your benefits you can take with you? This is a very important one. What do you have to tell the patients? And then if you're going to be hanging your own shingle, how should you move forward? So very broadly, those are the two categories or silos of information we're going to be talking about today. Jennifer, what would you add?
I would add that these are sort of broad concerns, and we're going to dig into some details and talk about a few things. And there are so many factors to consider, and every case is sort of unique. Every arrangement is unique. I highly encourage folks, you know, this is probably one of the most significant engagements or most significant decisions you're going to make as a physician if you're going to work for somebody else. I mean, this is your livelihood. This is your, you know, primary source of income. So it is worth investing time, effort, energy, and perhaps a few dollars in hiring somebody to help you through this process. I think that's really one of my biggest recommendations to folks is get some guidance, get some professional input, somebody who's read these agreements before and can explain what they mean, because they're often written in legalese that doesn't make a lot of sense to regular people. Much like physicians have their own language, well, lawyers do too. So.
Okay, so let's go into the new employment considerations then. You know, due diligence, that's really kind of a catchphrase we hear a lot these days, Jennifer. Can you kind of talk about due diligence that are aspects that a physician needs to think about before they decide to join a group?
Absolutely. This is what I often call the dating phase of a new relationship. Everybody needs to get to know each other. And you shouldn't be shy about asking questions, and you can interpret a lot by how those questions are answered or avoided. So you want to do your own research. You want to look at what's the reputation of the hospital. Are they, you know, in the news, not in the news? Do you know anybody else in the community that you can talk to about that particular group or facility? To the extent you can research online, you can sometimes find information about federal and state enforcement actions. There are lots of websites out there that report significant enforcement actions, and Google can be your friend there. It can really reveal a lot. So if they've had a reported enforcement action, it might be something you want to ask about. It's always, I think, and Robert, I think you'll second this, that you want to know what kind of compliance program they have and what's your role in it. What are you going to be asked to participate in as a part of the organization. It's often interesting. Go ahead, Robert.
Absolutely. You really have to know what you're walking into. Just last week, one of my attorneys and I were representing a medical professional up in front of the state board, and this individual had walked into a practice, and within 5 days of that, they had a surprise audit by the board to check out if they were meeting their OSHA requirements and the infection control and CDC issues. Turns out they weren't. So this individual that had just kind of stepped into this problem, they summarily suspended his license, and we had to go up there and get the suspension terminated. The point, though, is you need to be careful before you hook your wagon up to some of these guys, because you want to make sure that the group you're going to align yourself with really has taken steps to make sure that they meet all applicable regulatory and statutory requirements.
Yeah, and this is one of those areas where it can be really helpful to have a health lawyer in your corner. There's a lot of research we can do through resources that we're familiar with to perhaps, in some instances, in many instances, I mean, we can identify if there are major issues because they'll be reported in some of the places where we go and look for that information. Hospitals, for example, I can look at hospital survey history for every hospital that's certified by Medicare. Those are public information. There are websites we can access to get that information. So it is important, and I always encourage folks, don't be shy to ask those questions. What kind of survey history? Have you ever had any audits by Medicare or Medicaid? Ask those questions, and then when you get a yes or a no, ask another question. If it's a yes, I mean, really an experienced health lawyer can help you kind of tease out what those issues might be and whether they're important to you or not. I think it's really important, it's kind of moving on, to understand the financials of the organization. What's their payer mix? How much of their business is Medicare versus Medicaid versus private insurance? Do they have capitation contracts? What kind of payer agreements do they participate in? Are they part of an ACO? There can be a lot of questions that affect the financial viability of the practice. And, endocrinology is one of those areas where you do get a pretty good distribution of adult patients, but I would say you probably have more than your fair share of Medicare and Medicaid patients, just by the nature of the sorts of patients you guys see with the sorts of conditions that they have. So it's important to know, if they have a major Medicare audit or their Medicare money gets suspended and it's 75% of their business, that could be a problem. So it's just something you need to know going into these arrangements.
One of the questions that we have up here, Jennifer, that I think is so important, especially these days, is what are your referral sources? Where do you get your business from? Where does the practice or the hospital send its business to? And when you look at those sources of referrals, what is the business relationship between that practice and those folks that are sending you referrals? And, as we're going to probably talk about, we've got real issues these days with under the anti-kickback statute, Stark, and also now ECRA with private pay and with labs. So because the lab aspect of ECRA would, of course, impact endocrinologists. But the point, though, is before,
it's more complicated.
It really is. And all of these issues you're talking about also, it is important from a financial standpoint, but frankly, I like to think of it also as a measurement of risk. Because you have to figure out, how do they get their business, who are their, what is their payer mix, and, take that all into account, because, and whether or not they have an effective compliance program in place. I mean, those are all important questions. Now, compensation, this kind of goes right to the anti-kickback and Stark and ECRA questions, but you can kind of talk a little bit about compensation.
Sure. So it's obviously, this is almost always the most important element of any contract for somebody going into a new job, is how will I be paid? What kind of benefits am I going to receive? This is why you're here, right? Well, there are, in fact, 3 very specific laws now that affect employment relationships in the healthcare industry. Anti-kickback statute and the Stark Law have been around for a long time. ECRA is a brand new contract, and really it is more focused on employees of certain kinds of organizations in the substance abuse treatment in environment, but ECRA pulled in laboratories and does affect to a certain extent relationships between laboratories and their employees. Now, I don't know that it's likely that an endocrinologist is going to have a whole lot of issues under ECRA, but it is something to be aware of as you're looking at various relationships. And again, it's another reason why I think having a lawyer help you understand your contract and identify health risks or health law compliance risks is important. The anti-kickback statute and the Stark Law both have exceptions that apply to employment relationships. The anti-kickback statute is a criminal law that basically says you can't pay or receive money in exchange for referrals. And payment of employees who may refer patients within their practice or to the institution that they're employed by are actually covered by the anti-kickback statute. And there is an exception that permits a bona fide employment relationship. It's very broad, and to the extent you don't implicate other laws that are more restrictive like ECRA, 9 times out of 10, it's not going to be an issue for physicians. Now, Robert, you've had some very specific experience with that bona fide employee exception recently.
Essentially, what I hear you saying, Jennifer, and it's right on target, is under the anti-kickback statute, just very broadly speaking, the government really doesn't like compensation schemes that vary by value or volume. Having said that, if an individual qualifies as a bona fide employee, and I'm not talking about bona fide employee like the IRS defines it, there's actually a separate Supreme Court holding that defines what a bona fide employee is. In such a situation, then it is possible that if you meet the other requirements of the employee safe harbor, your compensation docs can in fact vary based on the work you're doing, the amount of referrals that you bring in or cases you handle, those types of things. But
Absolutely.
You have to remember, that's only for employees. So many of you, if you're thinking about, if they're suggesting perhaps you're going to be an independent contractor or have some other type of relationship, you really have to be very careful about your compensation scheme.
Correct.
And it's essential, and it's essential that you have a lawyer look at it, frankly, because we're talking about the anti-kickback statute here. We're talking about ECRA. Those are criminal statutes. Under ECRA, you can go to jail for 20 years. Under the anti-kickback statute, they raised it from 5 years to 10 years. So, this is not something to play around with. It's very important that you have someone look at your contracts.
Right. And there are different safe harbors and provisions that apply if you're an independent contractor versus an employee, and they're frankly a lot more restrictive. But you're quite right. Anti-kickback and Stark, these exceptions have been structured in a way that allows physicians who are employees and meet that employee test to be paid for their productivity. So along those lines, there are lots of ways to structure compensation. They can be based on collections, billings, net income. I'm seeing probably the predominant compensation structure I see now is based on work RVUs. And if you've never heard the term work RVU, RVU stands for relative value units. And what this means is essentially for every service that appears on the CPT code list, as published by the American Medical Association, CMS has determined that each service is worth a certain number of work relative value units. And there's a baseline that's 1 work RVU, and then things are then valued based on how much time, effort, and resources go into that service. So they're either less than 1 or more than 1. And I wish I could tell you exactly how they determine what 1 is, but suffice it to say that every specialty has its own benchmarks for work RVUs and what we would call sort of the median and then the percentiles around that median. So there are salary surveys and other surveys of compensation models and work effort that are done by organizations out there. The Medical Group Management Association is one of the biggest ones, but there are certainly others that do these surveys to determine sort of what is typical for your particular specialty in your particular geographic area. And they collect that data both on, on many different data points. One of those is work RVUs, and they can say for an endocrinologist, and I'm just spitballing this, but maybe it's average for them to do 6,000 work RVUs in a year, and the average person who meets that target makes X number of dollars. Most contracts I'm seeing these days are basing off of work RVUs in these salary surveys and structuring compensation around that. So it's important, though, to understand how they're doing the math in these agreements. And I spend probably the majority of my time, I spend a lot of time understanding and explaining how the agreement is structured, and then explaining the compensation structure, because they can be kind of mysterious, and the way they're drafted can be confusing at times. So you need to understand, what are your targets? What are you going to be paid? How much of that is negotiable? And I have absolute confidence that it's all negotiable until you sign on the dotted line. But you also need to be confident that your compensation is within that fair market value, that nebulous fair market value number. And Robert, why don't you talk a little bit about fair market value, because it's a little squishy to understand.
It is, and we see a lot of this on the physician side, where a physician works out maybe a practice works out some relationship with a hospital. What the government doesn't want, let's say that you've got a base salary, and there's all kinds of additional ways that you can be paid. You can be given a productivity bonus, a bonus for doing good work. Many times you're asked to serve as a medical director or a supervisor. All these things start to add up. Next thing you know, the salary, unfortunately, very well could exceed the fair market value of your services. In other words, if you're a physician and you yourself, or even if you worked 8 hours a day, there's a maximum amount that you could probably bill. And the government's going to look at what that would be. And if they're paying you more than you could possibly bring in, then the government's going to take the position, well, why would anybody pay a physician more than they actually produce in terms of revenue? Well, one of the reasons is because that particular relationship between a physician in the medical center or a physician in the hospital, you could generate all these ancillary services because of your admissions, because of lab tests, imaging, all across the board. And, the government's very concerned about there being this incentive of a physician really wanting to churn all these ancillary services in an effort to get their salary up higher than it really should be.
Right. So they see that as sort of an incentive to refer, which is problematic under anti-kickback and Stark.
Exactly. So, you do kind of have to watch out. You have to make sure that your income is something that the government would consider reasonable.
Right. Let's go to the next slide here. So the other things to look for are, especially if you're a little further along in your career, are what other revenue streams can you participate in while you're an employee? Sometimes you have performance incentives. Those are the productivity bonuses, sometimes quality bonuses that are added on to your salary. And then, are you allowed to moonlight? Are you allowed to do things outside of your employment and earn money directly for that? Or are you going to be expected to either ask for permission to do it and perhaps even turn the money over to the employer for that? I've seen all different variations on this. I've seen agreements where we've specifically carved out certain activities that physicians are already involved in. I was looking at one recently where a physician is going to become an employee of an organization, but they've already got a pre-existing relationship doing medical necessity review for an insurance entity. So we've specifically mentioned in that agreement that they're going to, they can continue to do that activity as long as it doesn't overlap or it's not done during their business hours working for their employer, and they're allowed to keep the money for that. But it's important that you address those things in the employment agreement so there's not gray area. The last thing you want is not to disclose all the facts and not to address things that you think may be issues because they're uncomfortable to talk about. It's always the unknown and the surprises that result in conflict. So I try to encourage folks, let's be transparent with each other and address these things. I think it's also really important not just to understand the benefits that come along with the job, but also, especially for physician employment, obviously, understand what kind of insurance, malpractice and liability insurance they're going to provide, whether it's going to be claims-made or occurrence insurance, and what are going to be your responsibilities if you leave that employment relationship as far as tail insurance, if that's something that's necessary. Again, I've seen different arrangements depending on how a contract ends. Sometimes it's the employer's responsibility. Sometimes it's the employee's responsibility. It's important to know that in advance. Tail insurance is really expensive, and you want to know going into it where you're going to land there. What's your obligation going to be if this relationship ends? Deferred compensation, stock options, severance packages, those can all become part of an employment agreement, either in general terms or by referring to plans that exist outside and are in some ancillary document. I see that a lot, especially with large organizations. There'll be a very general statement in the contract that you'll be offered the opportunity to participate in the company's deferred compensation or 401k plan. But there's very little discussion of it in the employment contract. That's very common. I think it's important there to say, okay, that's great. I need more information about what that is before I make a decision. I mean, those are important benefits, and it's, I think, critical for you to understand what you're getting. So it's important to ask for that additional info. Golden parachutes and deferred compensation for people who are further along in their career, those can become important because they can have tax consequences. So if that's you, then not only do you probably need a lawyer to help you draft and negotiate this thing, but you probably need a tax professional to talk to you about what that might mean if it came to pass. Liquidated damage clauses can be egregious and onerous for physicians. So anytime you see something that says something along the lines of, if you quit, you're going to owe the employer money back, that raises all sorts of red flags and alarm bells for me when I'm reviewing agreements, and I want to very carefully parse what that language says, when it applies, and in most instances when I'm advocating for the physician, try to get it out of the contract, frankly. But they do exist, and it's something to look for. I'm seeing more and more contracts where physicians are being asked to give indemnification against their own, not professional negligence, but things like bad coding, poor record keeping, things that would result in audit liability for the entity that they're working for, which is kind of scary because in some cases you can insure against that risk, in others you can't. So I don't know how much you've seen something like that, Robert, but I have seen these provisions that basically, and it's extremely common in recruiting agreements, and there's reasons for that the physician has to agree to, indemnify certain risks. And that's kind of new in the physician employment area. All right. So let's go on to the next slide.
Relocations and
speaking of recruitment, I've probably seen more disputes that involve recruitment agreements that went bad than any other kind. And it's a great incentive for the right sort of relationship, especially for young practitioners who are just starting out. It can really help you either start your own practice or relocate into an existing practice and sort of mitigate the cost of that for the practice that you join. Or if you're hanging your own shingle, help you start that new business with some financial security. That being said, recruitment arrangements generally involve a hospital providing certain financial incentives to a young or new physician or a physician who is relocating into the community to help subsidize their expenses, generally for the first year of their practice directly. These are generally structured as loans that have to be repaid, but that loan can be forgiven over time if the physician agrees to stay in the community. There are both anti-kickback statute issues here and Stark Law issues here. Both laws apply to these relationships, and both have safe harbors or exceptions that define when a recruitment arrangement is okay and when it's not. My experience has been they get structured perfectly fine in a compliant way on the front end, because the hospitals who do this generally have legal counsel that drafts the agreements for them. Where things get complicated is in the implementation of them. And it's important, I'm typically representing either the physician practice that's hiring the doctor or the doctor that's joining the practice. And where things get complicated is in the definition of terms. And we'll talk a little bit more about that on the next slide. But just to keep in mind here, practitioner recruitment under the anti-kickback statute needs to be structured to meet sort of the elements we've outlined here. You've either been in practice less than a year, or you're relocating into a health professional shortage area for your specialty, it needs to be in writing, and there are a bunch of different terms you've got to comply with. Interestingly, the hospital can't require you to refer if they're providing this incentive, but they can require you to have staff privileges. That being said, you can still have privileges at other hospitals as well, and they have to give you the latitude if you think it's appropriate to send a patient someplace other than this hospital that's giving you this incentive. You have to have the freedom to do that. But one of the important things to know about recruitment is that the payments that are made by the hospital are intended to help the new practitioner. They are not intended to help the practice they are joining necessarily. So they're intended to supplement and provide income to the practitioner and not just serve as a new income source for the practice. So let's go on to the next slide.
Jennifer, before we go on to the next slide, one of the things that I think it's important that we point out is, these agreements aren't a problem until they're a problem. Everything looks fine going on. But you guys need to understand that if in fact you decide that you can't, this isn't working out for you and you have to leave, or you want to move away, just because these hospitals may have been the nicest guys in the world when they recruited you, they're not going to necessarily be willing to waive any of these fees you having to pay them back. And it's important to understand why.
Right.
Yeah.
Most hospitals understand that they cannot walk away from that obligation to repay that loan. They view that, especially for hospitals who are subject to the Stark Law, if they don't comply with the practitioner recruitment exception under the Stark Law, they have to give money back for referrals that physician made to the hospital. So it really, their hands are tied to a certain extent. They have to pursue repayment of these monies if you didn't comply with the agreement. And that's not to say that there isn't negotiation that can happen in that process, but they cannot just walk away from it in virtually every case I've worked on. And hospitals tend to be, and it depends on the organization, but recruiting agreements are one of the areas where I often see hospitals actually go out and file litigation if they can't resolve whatever the conflict is informally. They just don't see a way not to, because they run the risk of violating Stark if they don't. So.
Right. So if you're going to be joining an organization and you're going to be given some type of relocation or recruitment bonus, you need to understand that you're going to have to fulfill that commitment, because chances are if you fail to fulfill that commitment and you want to leave, the hospital is going to take the position that they don't have much of a choice. They've got to go after you. Right.
And we can go on to the next slide because we've got a little bit here about, let's kick over to the next one. So let's hit one more slide there. All right. So what happens if you break your agreement? Well, as we said, the hospital's probably going to have to try to recoup the money that you owe them back. And the way these typically work is you get some amount of subsidy for the first year, and then for the next 3 years, usually, you work off 1/36 of that, or one prorated portion of that money you were given every month you stay in the community until you've fully repaid that obligation. And usually, like I said, it's either 36 or 48 months to work that off. If you leave, let's say in month 24 after you started, then there may be a whole 2 or 3 years left on your repayment obligation, and the hospital's going to come after you for that money. What you should understand, if you're unhappy with your employment arrangement, you can leave the employment as a group that you're with while you're in this repayment period. And so long as you stay in the hospital service area and you keep your staff privileges, you're probably not in violation of your recruitment agreement. These become way more problematic when a physician leaves their employment and then leaves town. And that's when you run into situations where the hospitals are going to really aggressively seek repayment of them. So there can be alternatives if you're not happy in an employment relationship that still allow you to satisfy your recruiting agreement. And I think it's really important if you're in that situation that you seek some legal counsel to help you understand what your options are.
Before you jump ship.
Before you jump ship, absolutely. All right, non-competes. Non-competes are pervasive. Practices invest money in bringing new physicians on and helping them build their practice, and they almost always want something in return for that, not just your time and effort and energy, but also your loyalty. And non-competition clauses are one of the ways they can ensure that if you leave, you're not going to go out and open up next door to them and compete with them. That being said, non-compete law is a creature of state law. There is no federal statute that governs what's okay as far as non-compete clauses. Some states permit them, some states don't permit them. In fact, I was just reviewing Colorado's non-compete law, and they, to a certain extent, limit what kind of non-competition clauses can exist in employment contracts.
As does California.
Yeah, and every state has its own interpretation of what's okay and what's not okay. They can be very, very complicated, I guess, is what I would like everybody to understand, and they vary state to state. So if there's a non-compete clause in your contract, generally speaking, they have to be reasonable in time and scope. And generally, courts are going to look at how long are you being asked to restrain competition, what are you being asked not to do, and what's the geographic area that you're going to be restrained from competing in. That's the general sort of, that's what we learn. When we learn about non-competes in law school, this is what we learn, right? Time, scope, and geographic area. In addition to the non-compete clauses, a lot of times you're going to see confidentiality clauses that will prohibit you from taking any kind of patient information, which can become complicated for physicians. Almost every state licensing law has some way or some provision that addresses continuing care for patients of that physician who elect that physician to be their caregiver going forward, or who are in the midst of an acute illness. It also applies like for pregnant patients, and there's some exceptions, and they're generally articulated in your licensing law. But it's important that you understand these provisions and know what you're going to be allowed to do and what you're not going to be allowed to do, and negotiate them. We spend a significant amount of time when we're talking about employment agreements trying to really clearly define those non-compete clauses, and if I'm advocating for the position, making them as narrow as we can. So non-solicitation is another element that generally gets lumped in with the restrictions on what you can do after employment ends. And non-solicitation generally means you can't solicit employees of the practice after you leave, that it can also extend to patients of the practice after you leave. And again, state law may define what a practice can require and what they can't. And the one thing to take away from is, generally speaking, non-compete and confidentiality and non-solicitation clauses, because they're governed by state law, some states say, even if you wrote a provision that doesn't comply with our law, if you're litigating what this means, the judge can rewrite it for you and reform it. It's kind of a dangerous thing, I think, for both sides of these agreements. I really prefer that we try to write something compliant on the front end rather than leave it up to a judge to rewrite it for us later when we're in the midst of a dispute. But some states don't allow that. And if you write a non-compliant non-compete, they just throw it out. So it's important to kind of understand what the ground rules are in your particular state.
It's also important to keep in mind that with regard to the contract, even if they do throw that out and say, our state doesn't recognize non-competes or non-solicitation provisions such as this, almost all of the contracts are going to have a separate provision that expressly says if any of these provisions are determined to be illegal or inapplicable, the rest of the contract still applies. So it's not like if it's got a bad non-compete that would throw out the whole contract.
Right. Right. So we call those severability clauses. So yes, absolutely. All right. So what happens? You want a contract to address how conflicts are resolved. And the usual run-of-the-mill day-to-day issues that arise in most practices are just addressed on the spot, and they don't become conflicts that require some kind of outside party to help resolve it. But I see more and more, especially in physician employment agreements and especially with large organizations, that they include some kind of alternative dispute resolution, whether that's mediation or arbitration. I think it's important. I think they're both valuable, useful tools, but I think physicians should understand what they're getting into when they agree to these. Mediation is non-binding. It's generally fairly inexpensive for both parties to participate in mediation, and essentially you hire a third party to help the parties try to come to some agreement on how to resolve a dispute. And that, you're going to probably pay an attorney to help you through that process, and you're certainly going to share the cost of the mediator. But in the grand scheme of things, it's a heck of a lot less expensive than litigation, and it's far less expensive than arbitration. Arbitration is a very formal process that looks like litigation, but private. So it includes, processes and procedures and rules that everybody follows. There can be limited discovery, just like you have in regular litigation. And at the end of the day, your arbitrator is going to decide the case the way a judge would decide the case, and they're going to issue a decision, and it's going to be binding on both parties. Arbitration in employment agreements, I don't see it as much as I see mediation. One of my concerns about arbitration, if I'm representing a physician, is it can be quite expensive. And the enforcement of arbitration decisions, you're turning the deciding of your case over to a private party who is not a judge. They're acting, and their decision can have the force of a judge's decision, but they make mistakes and they may not be experts in your area, and it's really difficult sometimes to challenge an arbitration decision that one party thinks is patently unfair to them. So if you're going to go down that road, understand arbitration costs the costs are similar to what litigation would run. It's binding, and your opportunity to appeal it can be very, very limited. So that being said, I am in favor of alternative dispute resolution for the right contracts, and I think mediation can be a really valuable tool.
Let's talk about choice of law and venue, though. We've had cases in recent, just over the last year, haven't we, Jennifer, where it turns out that the venue was a completely different state from where either party was located, which made it very, very expensive and inconvenient to try to challenge the contract.
I've read some agreements recently where you've got large multi-state organizations that are based in someplace other than wherever the physician's going to be working. And they want all of their litigation with that organization to be in sort of the home office's location, wherever that might be, right? Whether it's California or New York or Delaware or whatever. That can be really, really expensive for a physician who ends up in litigation with their employer over something. You're going to end up having to hire a lawyer in that state. You're going to have to travel for that litigation. It can be very burdensome. So this is an important thing to pay attention to if you're not working for a local practice or a local hospital that's based in your state. And it's just something to keep in mind. Look at this provision, read it carefully, and kind of try to put the pieces together from a geographic perspective. The choice of law is actually an interesting question, and it's not one that if you're not a lawyer that you're necessarily going to appreciate why it's important. So go ahead, Robert, I'm sorry.
But no, the choice of law is exactly where I was going. You have to be very careful because even if you're, let's say it's a physician in Texas, and they say that the venue is going to be New York, you have to watch and see, okay, well, whose law are they going to apply? Are they going to apply Texas law, or are they going to be applying New York law? Right. And
obviously, when we're advocating for one side or the other, we have our arguments both ways. But I think one of the more difficult things for courts to do is to have a state court in another jurisdiction applying the law of a different state. It can be, your results can be very unpredictable. Let's just put it that way.
Exactly. Corporate practice of medicine.
Right.
This is still an issue.
I live in the fine state of Texas, and there are still a number of states that follow the corporate practice of medicine, Texas being one of them. And essentially what the corporate practice of medicine means in most states is that non-physicians cannot directly employ physicians. And there are many variations on this general concept. Some of them permit co-ownership of practices between different kinds of licensed professionals. Some of them permit certain healthcare provider entities to employ doctors, but not others. Long story short, if you are in a state that has some version of the corporate practice of medicine doctrine, it's important to understand who owns the business you're working for and whether that's a compliant relationship. I cannot tell you the numbers of times I have reviewed contracts for folks in Texas only to discover that the entity that's trying to employ them can't. And it's often organizations from out of state that are establishing new businesses in Texas, and they think they can just duplicate the model they use in Washington State in Texas. And the reality is a lot of times that is not the case, and it does not work that way. So it's important to understand if the state where you're going has this doctrine and that the organization you're going to work for is compliant with it, and that not only is the ownership structure correct, but are they handling money in a way that's compliant with that state corporate practice of medicine? And I would throw in with the corporate practice of medicine concept, many states still have fee splitting provisions that sort of generally fall under this topic. And some of them have some really quirky issues. New York is one of them, about how certain payments and relationships work. So it's like I said, these are complicated relationships with a lot of regulatory overlay on top of them, and it's difficult for someone who's not real familiar with all these different aspects to necessarily issue spot them. So having some legal help can be a big advantage.
Now, what about if you're going to be entering into an organization and you aspire to be a partner in the organization, not just an employee?
So there are two ways this can go. Physicians who are fairly new in practice are often told that, oh yeah, we'll consider you for partnership in a few years. And you're given some real nebulous sort of pie in the sky, a sales pitch, for lack of a better description, about how of course, we'd love to consider you for partnership in the future if everything goes well. That can be interpreted in a lot of different ways. And I have young physicians come to me and say, well, they said they'll make me a partner in 3 years. And they sent me this agreement, and it doesn't really talk about that. That's pretty typical. Unless they are actually offering you partnership now, the likelihood that they're going to be really, really specific about whether they will offer you partnership or not is low. They don't want to tie their hands. You don't know each other. They're going to throw some language in there that says that we'll consider you, but ultimately it's up to the partners and the partnership to decide whether to move forward with that at the time. So just know in advance that buy-in provisions can be very, unless you're actually buying into a practice right away, they can be pretty, they don't have a lot of teeth or a lot of enforceability associated with them. Now, if you are buying in, that's an important thing. There can be some complicated provisions and tax consequences associated with, buying into a partnership. So I absolutely suggest, you're not just going to be signing an employment contract. You're probably going to be signing on to either the bylaws of the organization or an LLC operating agreement. You may be asked to sign shareholder agreements that restrict the ability to sell your interest and other organizational issues. You really do need a lawyer if you're buying into a practice to help you understand what you're getting into. Now, moving on, making the relationship work. This is the psychological side of things, I think. It's really important to keep the lines of communication open and professional. I encourage folks to talk. You just have to talk to each other, and what I see often is the questions that don't get asked that become a problem. I like to see very transparent communication about money. You should understand as a physician where you stand in the larger scheme of the practice. That's not to say that as an employee, the practice necessarily is going to show you all of their financials, but you should understand the things that are relevant to your compensation. So what's your revenue look like? How are the billing and collection folks doing on your claims? What are your expenses? And how are those expenses calculated if you're being expected to absorb certain expenses as part of your compensation methodology?
Let's go on to professional services agreements, because we're starting to run out of time on this here. That's
okay. So PSAs are those extra things that you may be asked to look at. So medical directorships, on-call coverage agreements. These are the extra things outside of just being a doc and providing services. Important to know is almost all of these agreements are subject to either the anti-kickback statute or the Stark Law. They need to be structured in a very careful way. They need to, obviously, you need to be paid fair market value, and there are a host of other requirements. So if you are considering a PSA, we've outlined here some of the anti-kickback statute requirements for personal services and management contracts. As you can see, there's a laundry list of requirements, and they're pretty complicated. The Stark Law has very similar requirements. The keys being written agreement of not less than a year. They have to be for services that the other organization actually needs, and your compensation needs to be set in advance, fair market value, and not determined in a way that takes into account the volume or value of referrals. Those are harder to meet than you might imagine, but there are ways to structure these that are compliant, but I do recommend you get some legal counsel to help you understand whether that contract is compliant or not. Let's go on to the next slide.
Yeah, and before we go on, under the anti-kickback statute, folks, it's important to remember there's more than 20 safe harbors, as they call them. And there are a number of exceptions under Stark. This isn't an analysis, frankly, that you should try to do by yourself, because these are very complicated analyses. And the whole purpose of the exceptions and the safe harbors are really recognitions by Congress that both the anti-kickback statute and Stark are extraordinarily broad, but there are certain factual situations where a certain business arrangement does not really represent a significant risk to the Medicare Trust Fund, and therefore, if you meet specific requirements, they will not consider it to be a violation of law.
right? And I would just add to that that keeping in mind that the anti-kickback statute is a criminal law, just because you don't meet a safe harbor doesn't mean you violate that law. But it does mean that the enforcement authorities are going to look at all the facts and circumstances of a relationship when they analyze it. So if you're in that gray area, it's even more important to have some legal counsel help you understand what your risks are and what you can do to mitigate those risks. So
now, Jennifer, we've kind of talked about now on the employment relationship on the front end. Let's kind of shift gears now and talk about, okay, what about on the back end?
Right. So generally speaking, most employment relationships do eventually come to an end, either because you become a partner or you relocate out of the community for some reason, or maybe you just don't get along. Maybe it's just not a good fit, or maybe you retire. So let's go on to the next one. So there are different termination provisions that you may see in your employment contract. At-will employment is not as common in physician employment as in other sorts of employment relationships. I would say 9 times out of 10 employment contracts may include what we call without cause termination, but it requires advance notice. Sometimes those notice periods are long, and it generally allows either the employer or the employee to give notice to the other side that they want to leave. And there can be different things that happen based on whether you're choosing to leave without cause or if you are terminated for cause. Now, for cause termination can be for lots of different reasons. It can be for just not complying with your employment contract, or it can be for some of these ancillary things that happen that are sort of on our radar all the time. What if you have a licensure action? What if you get in trouble with the Medicare program? What if your billing privileges get revoked? What if you end up on the exclusion list? What if you're convicted of a crime? What if there's just a whole host of different things that can fall under that for-cause termination provision? And oftentimes, the for-cause termination gives you fewer rights and will end up with you having a lot less money in your pocket than under a without-cause termination provision. So it's important to know what those 2 different reasons or ways you can get out of a contract, what they require as far as notice, and then what happens after. So let's go to the next slide. So that being said, be sure you've read your contract and understand what kind of notice period exists and what kind of notice requirements exist. Without cause, like I said, it could be a 30-day notice, it could be a 60-day notice, it could be a 90-day notice, and generally notices have to be given in writing to a specific person at a specific address. I've seen people argue over whether effective notice has been given, and it's just so simple to comply as long as you just read your contract and understand what it requires. So if you're contemplating terminating something with cause, then it becomes even more important to write down what that cause is. And I encourage folks at that point, if you're considering a with cause termination, you're going to break your contract with either as the employer with an employee or as an employee with the employer, you probably need a lawyer to guide you through that process. It's important to make sure that when you do put things in writing that you do it in a way that's effective. But once you have decided to break up, there are important things that may be addressed in your contract, including who's going to notify patients, who's going to pay for copies of patient records if patient records end up being transferred between the practice and the departing physician. How is your outstanding compensation and bonus going to be handled? Will you get your bonus payment? Will it be reduced in some way? Will it be paid out at a later date? If your pay is dependent on collections, is there an end date for when they'll continue paying you? Are they going to collect money for the next 60 or 90 or 120 days and then it's going to stop? What obligations does the employer have to file claims after you leave? How are patients going to be transferred between the parties, or will they? And understanding that state law can often influence that requirement. And then who's going to be responsible for tail coverage? Who's going to pay for it? How long does it need to be? what kind of options exist. Let's go to the next one. So this was a case study of a contract termination. OB-GYN had a 3-year relationship, and the physician decides not to pursue partnership, citing personality conflicts. She wants to go through an orderly termination, so we reviewed her contract and advised her regarding her options. She was owed some money in incentive compensation from the previous year, as well as some incentive compensation for the current year. And the total owed to that departing OB-GYN was around $100,000. The OB-GYN was capable and well-liked, and based on these factors and the nature of the services she provided, the OB-GYN thought that most patients would want to transfer to her new practice. So patient transition was important to her, and she did not have a non-compete. What we tried to do was structure an orderly transfer, and actually this one went really well. She gave advance notice to her employer, so they had plenty of time to backfill her position so that they wouldn't be left without an extra hand in the practice to take care of patients. Written notice was sent. We decided early on who was going to notify patients, how tail insurance would be handled, what billing and collection would look like, and ultimately, the incentive compensation issue was resolved. We set a timeline for it in a way that it would be paid. And this was an orderly transition because this young doctor who had a written contract sought advice early on about how to go through this appropriately. And frankly, her employer was professional and reasonable about it. I've seen lots and lots of cases in real competitive industries where it doesn't play out this well. So let's go to the next slide. And this would be an example of the one that didn't go as well. This is an orthopedic surgeon who was in the first year of a 5-year employment agreement with a rural hospital, and he'd received a lot of incentive money to come and relocate. Major issues arose, and the physician communicated those concerns, but the hospital didn't really do an effective job of addressing them, and the physician eventually got fed up and sent an email to the CEO giving minimal notice that he was going to leave. Let's just suffice to say that it wasn't the kind of notice that was contemplated by the contract. And the email didn't explicitly refer to the hospital's breach of his employment relationship. So it was not a great notice. The hospital ultimately demanded repayment of a pro rata portion of his signing bonus, all his relocation expenses, and a liquidated damage clause. And that was a significant amount of money, far more than this physician was prepared to pay. Unfortunately, he didn't call his attorney until after he sent these emails and other communications to the hospital, and after the hospital was already demanding money from him. Then he engaged counsel, and the agreement had a mandatory arbitration provision in it, and ultimately the hospital did seek arbitration, but we were involved at that point and were able to eventually negotiate a resolution. But I would think we probably could have achieved a different and much better result if we'd been involved very early on in the process to advise the physician about how to extract himself from the relationship given all the issues that existed. So in this case, the physician ended up paying the hospital back quite a bit of money because it just was a difficult situation with a contract that was written very much in favor of the hospital. So let's go to the next one. A little bit about benefits when you leave. COBRA for health coverage, which I think everybody's fairly familiar with, but that tail coverage is important. Most employers have claims-made coverage. It's going to require you to purchase a tail policy to cover the statute of limitations for healthcare claims after you leave. Every contract has different language about tail coverage. Many of them say if you're terminated for cause that you're going to have to pay for that tail coverage, and you should know that it can be really, really expensive. I have seen scenarios, though, where physicians go on to a new job, even where they are responsible for paying for that tail coverage, and either the new employer will pick up some of the cost or will kind of share it with the physician that's coming on as a new employee. So sometimes that's negotiable. It's just something you need to be aware of. So the next one. State license notice requirements. Yeah, Robert, why don't you handle that?
Well,
I know you have some experience there.
Notice requirements really are important. Whenever you're going to, we've had a number of board matters just over the last year where a physician changed jobs, didn't tell patients, and also didn't notify the state board that they were moving. It resulted in a complaint being filed against the physician, and in one particular case, the DEA went after them because they are supposed to be kept apprised of any changes in a physician's practice address. Now, on the Medicare side, you and I see a number of cases that have led to revocation because a physician failed to advise Medicare when they actually moved.
Right. It's really, really important that you keep your individual enrollment record with Medicare up to date. And when you leave a job where you've been Medicare enrolled and you've been reassigning benefits to your group, that you terminate that reassignment and that you take the appropriate steps to inform Medicare, where are you going to be? Where are you leaving and going to? I get revocation actions every single year where a physician has failed to tell the Medicare program that they changed locations. And Medicare sent maybe a revalidation request to the doctor that they never saw. And ultimately, when the physician didn't respond, they deactivated their provider number. So, those situations can usually be fixed, but it sure is alarming and time-consuming and not a scenario you want to find yourself in. So, something to be aware of when you leave a job. It's really important that you tell everybody who needs to know that you did.
Hanging out your own shingle. Let's say, for instance, that you've decided to leave your current employment and you want to open up your own practice. Well, congratulations, but it's a lot of work. And you need to make sure. Yeah, and you need to consult a lawyer, first of all, to figure out what type of legal entity you need to be setting up.
Right.
You're going to want to.
If there's one thing I could tell a doctor hanging out their own shingle is never, ever, 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 ever be a full proprietor.
Exactly.
You are taking on every bit of liability, both for your personal professional liability, but also for business debts. And most businesses or physicians that start up a new practice have to borrow some money generally, whether that's through a line of credit or some other kind of business loan. Unless you've incorporated your entity, you're going to have very little in the way of liability protection. And I would say for young doctors who are just starting out, you're probably going to be asked to give personal guarantees. And to the extent you can negotiate some of that, it's important to think about that. But, I've helped doctors start practices many, many times, and it is complex. And the timing of certain things is important. You got to incorporate, you got to find a location, and then you got to worry about how you're going to get paid. And then you've got employment issues and staffing issues and workers' comp and payroll and just a whole host of issues you've got to think about. And it takes time to put these things in place. So it's good to find somebody who's not only good at helping people start a new business, but who knows something about healthcare. You really can't go to your run-of-the-mill business lawyer to help you start a medical practice, unfortunately. And these are just some of the other things you really have to think about when you're starting a new practice that really, they have some to do with the legal side of things, but really, these are practical matters as well. What are your operational needs? Staffing, equipment. Are you going to sign leases or other contracts that you need a lawyer to review? Your electronic medical record or electronic health record and your billing tend to be two of your more significant contracts that you're probably going to enter into. They are probably going to be some of your bigger ticket items money-wise. I really, really encourage you to have legal counsel review those contracts. Most EHR vendors have very formulaic template contracts that give you very little in the way of, you don't have a lot of negotiating power with them, let's just put it that way. But you really do need to understand what they say. What are your rights going to be? Is this a contract you can terminate? How hard is it to get out of? Is it going to cost you money to get out of it? How do you secure your data if you change vendors? What will they do to help you transition from one vendor to another? And for your billing contracts, Robert, you do a ton of work in the billing area. So what are some of the things to think about in those billing agreements?
Well, you have to keep in mind on the billing side that the rules of the road vary from state to state. For instance, in the state of New York, you cannot pay a billing company, a third-party billing company, a percentage, regardless of whether it's Medicare, Medicaid, or even private. There are other states, such as Texas, that have fairly recently made changes in their Medicaid participation agreement that really make it to where you're not supposed to be paying a billing company a percentage for any Medicaid claims that they process. In some states, if you use an outside biller outside of your office, you have to actually register that with the state. And in some states like New Jersey, they actually want to see a copy of the contract you have with the third-party billing company. So I'm all in favor of using experts to handle your billing, because the third-party billing companies out there that are doing this work, a lot of them are doing really, really good work. And it's real hard for you in a new practice to hire someone and get up to speed on the billing side. So I would definitely recommend that you use a professional. But be careful, because the rules vary from state to state as to how you can compensate the billing company. Can you pay them a percentage? Can you pay them, from a compliance standpoint, of course, OIG would much prefer, rather than you paying a percentage, they really would like for you to base it on a flat fee per month, or an hourly fee, or even a per claim fee. All of those are considered to be more compliant than a percentage. So just be careful when you're hiring a third-party billing company.
Right. So in addition to that, it's an expense that's well worth absorbing, and that is get a compliance program in place and train your staff. Virtually, well, I shouldn't say that. There are requirements in many states under their Medicaid programs that you have a compliance program in place. Texas is a great example. It's in the Medicaid provider agreement. You agree in that document that you have an effective compliance program. There's a federal law that says that Medicare providers will have an effective compliance program. And that can mean many different things depending on the size of your organization. And there is no one-size-fits-all compliance program. But there are certainly aspects of them that are common among providers. And there are certainly areas that are very important for you to address. HIPAA is a big one. We write compliance programs all day long, and the HIPAA compliance part of it can be one of the more challenging areas. And understand that the minute you turn on a computer or submit an electronic claim, you are subject to HIPAA, and you have to have a full HIPAA risk assessment of all of your IT connections to the world. So it's not something you can kind of delay, I guess, until you've got more time to think about it. So in summary, here's sort of the things that we think about when we're looking at employment relationships. I like the first one. If possible, date first before entering into a business arrangement. This just means spend some time, invest some time in getting to know each other. And I would add to that, it's never wrong to shop around. You don't need to commit to the first offer that's put on the table unless it really is too good to turn down. But it's hard sometimes, especially when you're new in practice, if you've never really looked for a job and you haven't had multiple opportunities to consider. A lot of folks, especially those coming out of fellowship, they have a tendency to jump at the first thing and think it's the only opportunity they're ever going to have. So I encourage people, look around and see what kinds of alternatives are out there. And then when you find something interesting, find a health lawyer to help you understand what's being proposed, review those agreements, and help you negotiate them. Really do your homework on the organization to the extent that you can. Be very transparent with your legal counsel, both about what you want out of the relationship, and your legal counsel should do you the service of fully explaining the agreement to you and answering all of your questions. I do absolutely like written contracts for employment relationships for doctors. I think they're really important so that everybody understands the ground rules. You should be familiar with those federal and state laws that affect employment and recruitment relationships. Make sure your attorney has done these before and understands them. You can't just go out and hire any old business lawyer to look at a recruiting relationship and think that they're going to be able to advise you about healthcare compliance. That's just, you can't hire the person who handled your friend's divorce to do this. It's just not going to be a great move. But I do encourage you, if things start going badly, that you contact an attorney to help you walk away from a relationship if that's what you want to do. It can be important to get some advice about the best way to go about that. So with that being
Jennifer,
said, Robert, parting words?
I think we have a few questions, or at least one question before
Sure.
we move on. One participant wanted to know, where can you find the RVUs for specialty per geographic area? Where can you get that type of information?
Some of it is proprietary, but if you Google work RVUs for your specialty, you'll be surprised what you can find out there on the internet. Now, I would say take that with a grain of salt. I'm just going to do one here. Work RVUs, endocrinology, median. And Becker's Hospital Review has a story, and it'll give you, and this is generally not going to be the most current up-to-date information because a lot of the most current up-to-date information ends up being proprietary, but it's going to give you a breakdown, and it's going to say, here's what the median was for endocrinology in 2015 nationally, and it's going to say, median work RVUs were 4,677, and median compensation nationally was, $242,000. So you can find a lot of information out there in the public domain that can help sort of give you a direction. That being said, the most current data is going to probably be proprietary and cost you some money to get access to. When I'm negotiating for doctors, I ask the practice to show me their data, and 9 times out of 10 they will. If they're reluctant to show me their data, then I kind of want to probe why that is. So I would suggest if I believe Medscape also publishes some pretty good resource information. Professional organizations often have salary surveys that they take of their members. So that's another place, either through your state medical association or through a professional association specific to endocrinology. I would ask if they have that kind of data as well. So those are a few public resources you might be able to access.
Thank you. Okay, so Jennifer, folks on the phone, if you have any questions about contracts, if it's a new contract or even an existing contract and you're thinking about leaving and you want to know what your obligations are, feel free to give us a call. We'd be happy to advise you. Our contact information is on the phone, is on the screen now. You can call through our main number and ask for either me or Jennifer. Jennifer, do you have any closing remarks?
Nope, that's it. I'm happy to answer questions. And as Robert said, call or email anytime.
Okay, thanks a lot.
Thank
Bye-bye.
you.